ongoing now shall proceed as scheduled on the other grounds, save for the grounds on the affidavit which is reserved for Wednesday. Senior Counsel Gitu, take your stand.
Thank you, my lords and my lady. I had mentally wound down, but I will obey your injunction straight away. I appear, my lords and my lady, instructed by the Honorable Attorney General, and I appear here with Christopher Marwa, Deputy Chief State Counsel. We are happy to confirm to the court that grounds of opposition dated 24th November 2024 have been filed, and written submissions dated 4th March 2026 have also been filed. I propose to address one issue, one fundamental legal issue in several parts. And that issue is, what are the constitutional limits of this court's jurisdiction over impeachment proceedings, and why both the threshold and the merits of the consolidated petitions have failed? My lord, it's common ground among all counsel here that impeachment is not an ordinary constitutional proceeding. In the words of the Supreme Court of the Philippines, it is a sui generis proceeding, a constitutional measure designed to protect the state from official delinquencies and its political in character. I know it's been submitted by my learned friends repeatedly that these impeachment proceedings are not of a political character. In fact, impeachment proceedings globally are political in character. And there is an article referred to in our submissions, which my lords will find, which is an article that summarizes global trends in impeachment proceedings. In fact, here in this country, the very point that my learned friends deny has been consistently affirmed by our courts. Let us see what the court said in Kaweria Mwangaza versus the County Assembly of Meru and another. Justice Edward Mureithi, your learned distinguished colleague, sitting in Meru, affirmed that impeachment is inherently political and is distinct from the judicial process. So it is sui generis, we all agree. You will look at our submissions at paragraph 22 to 71. Our submission is echoed by the second respondent's submissions at paragraph 50 to 96. And we draw on comparative analysis. We've looked at the United States, the Philippines, South Korea, Brazil, and Nigeria. There are three distinct features about impeachments and other accountability mechanisms. First, and my learned friends have made heavy weather of this, mandatory public participation. But I want to pause there and to remind ourselves, the public is not participating so that it may make the decision whether to impeach or not. That is not the work of the public. The public is participating so that this political process may be informed. Number two, strict constitutional timelines. And three, bicameral supermajoritarian requirements, both at initiating it and at the removal. This is not accidental draftsmanship. These are deliberate constitutional choices that vest the impeachment power firmly and finally in the hands of Parliament, and not the courts, in the hands of Parliament. Why? Because Parliament is elected. Parliament is an elected body. Political accountability is to an elected body that we call Parliament. The courts are not elected, and that is deliberate in our constitutional democracy. So we cannot have a counter-majoritarian situation where the elected representatives make a decision which is then reviewed for policy purposes by a non-elected branch. And I will be making it very clear in a very short time. That is not to say that the High Court does not have constitutional oversight over Parliament. It does. The High Court has constitutional oversight over Parliament. What does that mean? That this court, and that's why we are here this afternoon, must satisfy itself that the rights of the petitioner were respected. What can't this court do? This court cannot say, like you have been invited, that why does that particular MP say that this man was rude to another man, therefore he's impeaching him? That is beyond what you can investigate. Kenya, this our beloved republic, we have put a threshold for impeachment that is one of the highest in the world. We have made it more difficult to impeach than any other country that we can think of. You can look at paragraph 66 of the second respondent submissions, and it will illustrate that our criteria is one of the most demanding in the world. Look at the United States that prides itself as the biggest democracy in the world. You require only a simple majority in the House of Representatives to initiate impeachment. In Kenya, you require 2/3, almost an impossibility. Under the old constitution, you require 2/3 to change the constitution. It's a very, very, very high threshold. In the proceedings now before you, my lords, we have 282 members who voted in favor. 44 voted against. That is not a partisan squeak. That is a constitutional supermajority of extraordinary proportions. Some explanation has been given as to why Parliament votes in this way. We have no evidence. No evidence has been brought before you. It's political opinion, and whoever holds it is entitled to it. Let me come now, my lords, to what is your duty in the humble submission of the Attorney General of Kenya. What is the duty of the court when we have reached this point? Should this court proceed to a merit review of the impeachment? Should it relitigate the proceedings as the petitioners very boldly demand? Our respectful answer is that you should not, and you cannot. You must resist the invitation to turn these proceedings into a merit review of the impeachment. If Parliament was full of wise men, would they have reached this decision? If the Senate was full of angels, would they have reached this decision? And that is one question you should not be tempted to answer. What, in our very humble view, should you do, my lords, as your duty? Your very simple duty is to ask yourselves, was there a violation of the constitutional rights of the petitioner? That's all. Was there a violation of the constitutional rights of the petitioner? That's a narrow, very, very narrow inquiry. This is not my personal opinion. It is the settled jurisprudence of the Republic of Kenya. It is the settled jurisprudence of the Republic of Kenya as enunciated by the Supreme Court of Kenya, the highest court in our republic, in the case of Sonko versus the County Assembly of Nairobi City and against 11 others. This is what the Supreme Court said, and I beg your indulgence to read verbatim. Likewise, in Justice Kariuki Mate and another versus Martin Nyaga Wambora and another, this court signaled that it would be reluctant to question parliamentary procedures as long as they did not breach the Constitution, and that the mandate of the court is restricted by the doctrine of separation of powers to deciding on matters of individual rights and fundamental freedoms, and to inquire into how the County Assembly and the Senate perform duties in which they alone have the discretion, or to review the merit of the decision by the County Assembly to impeach the governor. What does this mean in practical terms for today's proceedings? This court is called upon not to review whether the charges against the first petitioner were approved, not to assess whether the evidence was sufficient, not to determine whether Parliament reached the correct conclusion. This court is called upon only to evaluate whether the first petitioner's constitutional rights to due process were compromised, and nothing more. So heavy weather was made by my very honorable and distinguished learned friends, led by my very own friend, the Honorable P.K. Mwite. Heavy weather was made of all manner of allegations relating to process, who initially was to bring the petition, who ended up bringing the petition. All those are irrelevant. Only one thing is relevant. Were the petitioner's constitutional rights to due process compromised? From where we sit, I am instructed by the Honorable the Attorney General to advise the court that no violations have been demonstrated in the petitions now before you. Further, I wish to submit this. The evaluation you will make, my lords, as to whether the petitioner's constitutional rights were compromised is not an abstraction. It must be anchored in the constitutional text itself. The petitioners must demonstrate that the constitutional right that was violated is this one and that one and that one. No generalities, no abstractions, specifics. This is what we are commanded to do by Article 151, Article 152, Article 144, Article 145. Article 152 provides that the provisions of Article 144 and 145 relating to the removal of the president shall apply mutatis mutandis. We must thank God for a little Latin still left in the Constitution. There was a submission made, unless I misunderstood it, that there exists only a provision for the impeachment of the president and none for the impeachment of the deputy president. Nothing could be further from the truth, because Article 144 and 145 apply to the removal of the president mutatis mutandis. It is therefore, my lords, Article 144 and 145 that we find the standard. That is where we will find the standard of how the petitioner ought to have been treated. In our very humble submission, my lady and my lords, this petition must fail. This petition will fail not because the first petitioner's concerns are not important, they are very important, but because the remedy he seeks is constitutionally unavailable. What does he ask the court to do? One, he asks you to reopen and re-examine the impeachment proceedings. You have no jurisdiction to do that. He asks you too to re-evaluate the evidence placed before the National Assembly and the Senate. You have no jurisdiction to do that. Three, he wants you to determine whether the constitutional threshold for each ground that he faced was met. Meaning, he's asking you to rehear the proceedings and reconsider the evidence. You have no such jurisdiction. 5, he wants you to quash the resolution of both houses and declare his impeachment null and void. So he's asking you to sit as a court of appeal on the decisions of the National Assembly and on the decisions of the Senate. That is exactly what the Supreme Court in the Sonko case has said no court should do. So my learned friends are flying into a wind, a headwind that they cannot overcome. What they want has already been declared by the Supreme Court as not able to issue from this court. When we look at Article 144, sub-Article 8, which applies mutatis mutandis to the Deputy President by virtue of Article 150, sub-Article 2, that is the situation the Constitution itself sought to foreclose. I know you will be told, and have already been told, and I've been in your court long enough to know that you've been told this many times. The spirit of the Constitution. Before we look for the ghosts and the spirits of the Constitution, we must look at its plain language. The language of 1448 provides finality to the Senate's decision. On the night that the Senate carried out its vote, your petitioner stood impeached. It did not await any other action by any other body or authority. So Article 1448 provides the finality of the Senate's decision. It's not subject to appeal or review on the merits. On the merits. To accept the petitioner's invitation to sit as an appeal court would be a violation of our Constitution and the law. Now, I want to refer you to a very well-reasoned decision of the Court of Appeal. Justice Visram, Justice Kome, Justice Otieno Odek, and they were making a point with admirable clarity on this point. And they said this: in the sequential steps identified above, courts have neither been vested with jurisdiction to initiate a motion, consider a resolution, nor to hear the charges leveled against the governor. The constitutional and statutory mandate to initiate and consider a motion to remove a county governor is vested in the county assembly and the Senate. Insofar as the process of the removal of governor from office is concerned, the province of the court is solely to decide on the rights of individuals and not to inquire how the county assembly performs duties which they have discretion in. Same point as in the Sonko matter. This court, all courts, have no jurisdiction to do a merit review of the decision of either the National Assembly or the Senate. This point had equally been made earlier, rather later, in Mumo Matemo versus the Trusted Society of Human Rights, Keka for 2013, by the Court of Appeal, a very strong Court of Appeal, William Ouko, Gatembu Cairo, and A.K. Murgo. And this is what they said, addressing the specifics of the separation of powers doctrine. Separation of powers does not only proscribe organs of government from interfering with the other's function, it also entails empowering each organ of government with countervailing powers which provide checks and balances. There must be judicial, legislative, and executive deference to the repository of this function. The word they use there is very important, deference. To give due respect, to give due respect to the decision of another. We in the judicature must give due respect to the ambit of Parliament and to the ambit of the executive. That's what our courts are saying. Why shouldn't you accept a merit-based review of the decision placed before you? Let me give you a hypothetical of why that can create a lot of chaos. If you assumed a merit jurisdiction, what would stop the National Assembly, represented here by my very good friend Eric Gumbo, appealing to this court against the Senate's decision to acquit on the 6 of the 11 grounds? Remember, your petitioner is acquitted on the major grounds. If he himself can come on appeal to you, the National Assembly can come to you on appeal on his acquittal. That is not what the drafters of our Constitution intended. They did not intend to have you, my lords, sucked into political disputes by politicians within their political organs, which is Parliament. There is another question which is important. I know there is no unanimity on this question, but in my own view, it's a very important question. And this is the doctrine of the political question. I know after 2010, the popular opinion became that any person at any time over whatever grievance he has can approach the court. We removed the rules on standing. You don't have to show how you are related to a matter. So the county government of Meru and the county government of Isiolo, they negotiate for many years a water sharing agreement. And on the day they're about to sign it, a man from Dumberi rushes to the High Court in Kiambu and says, stop that agreement. Who is he? How is he related to Isiolo? How is he related to Meru? Nobody knows. He wants an injunction. I think the rules about standing are common sense rules. And therefore, the political question doctrine, the doctrine that there are issues, there are controversies that are not amenable to the judicial process. It's a rule of common sense. There are processes that are not amenable to the judicial process because they are largely raise political controversies. Let me go back to the Supreme Court of Kenya in Sonko 2022 at paragraph 110. In considering applications to review decisions of other branches of government, Courts should strive to achieve a balance between their role as custodians of the Constitution and the rule of law, including an obligation to respect what Parliament is constitutionally required to fulfill. To respect, again, the doctrine of deference. Parliament will have the discretion and the power to regulate its own affairs. The courts will be slow to interfere with the exercise of that discretion, end of quote. The Supreme Court returns to this issue yet again in the case of Cabinet Secretary for the National Treasury versus Okoiti and 52 others. What does it say? Considering the discretion vested in Parliament in fulfilling its constitutional duties under the values and principles of governance outlined in Article 10(2) of the Constitution, the role of the courts is limited to reviewing whether the measures put in place by Parliament are reasonable and in conformity with the Constitution and the law. In other words, Article 165 does not confer to this court unlimited jurisdiction. It grants supervisory jurisdiction, not appellate authority over Parliament. This court may inquire into whether the procedure prescribed by the Constitution was followed and whether the first petitioner's rights were respected. It cannot inquire into whether the charges were proved, whether the evidence was sufficient, or whether Parliament reached a correct decision. The essence of that is a merit review, and it is expressly. Let me return to the case of Wambora, and this is what the Court of Appeal says, quote, "The province of the court is to decide on the rights of individuals, not to inquire how Parliament performs its discretionary duties," end of quote. My lord, my lady, I want to come to my second last structural point, which I think is a very fundamental one. Impeachment does not merely sit at the outer boundary of this court's supervisory jurisdiction. It does not sit at the outer boundary of this court's supervisory jurisdiction. It falls squarely within the domain of non-justiciable political questions. To the extent that the petitioners are arguing merits, that's a political question, and it's covered by the political question doctrine. The Supreme Court of the Philippines, we return back to its case, Sara Duterte. You will recall, my lords, she was the vice president. She was facing impeachment, and she went to court for protection against that. This is 2025, last year. Her father was the former President Duterte, now unfortunately at the ICC in The Hague, facing some charges, but that's beside the point. What the Supreme Court of the Philippines says, and I quote, "The court will not encroach upon matters that rightly fall under the authority and wisdom of a co-equal branch, or matters classified as political questions. The court will thus not delve into the merits of this impeachment complaint." Mr. Duterte was sort of asking the court to find that the charges were not tenable, they were not brought in good faith, and so on. The court said, that's not our work. Why should this court find that these petitions before you fall within the reasoning of the Supreme Court of Philippines decision in the Duterte case? For three reasons. First, impeachment is textually committed to Parliament. Articles 145 and 150 vest the impeachment power in the National Assembly and the Senate. Not in this court, nor any other court. The constitutional text is clear. It makes no provision for judicial participation in the impeachment determination. That silence is not an oversight. It is a deliberate allocation of authority. Secondly, we have to look at the criteria that the Constitution itself, by extension, the people of the Republic of Kenya wrote into that document. It is, quote, gross misconduct. 2, gross violations of the Constitution. 3, serious reasons to believe. These are not judicial, they are not judicial evaluation standards. They are political evaluation standards. If your peers vote that they believe that your conduct is gross, if your peers think that your conduct is gross, then it is gross. Because the Constitution says, when we know whether you have acted in a gross way, we will not ask anybody, we will ask your peers. It is not what a judge would think. A judge would say, this has to be proved to a high standard. It's a gross, in our business, my lords, your business, our business, we always say that if you make, for example, an allegation of fraud, that is a very serious allegation. The standard must be high. That's not the way the political class approaches these matters. When they are asked, has this man behaved in a gross manner? They are answering a political question. They are not answering a legal question. So, when a court attempts to assess whether conduct amounts to gross misconduct, as you've been invited to do by my learned colleagues for the petitioner, then the court is not adjudicating anymore. You are not being invited to adjudicate. You are being invited to substitute the Parliament's opinion for yours. That is a dangerous path that flies right against the doctrine of the separation of powers. The Constitution doesn't allow it, and there is a very good reason it did not. Third, and this is probably the most telling, the outcome of impeachment depends on political judgment. It depends on the Senate's collective assessment or whether the conduct of the holder of a constitutional office has fallen so far below the standard demanded of that office to warrant the termination of a popular mandate. That judgment is entrusted to elected senators, answerable to the people, and not to judges. If the people believe that your petitioner was wrongly impeached, they will not vote for these senators at our next election. They will say, you were part of the people who treated so-and-so badly. So they have a political remedy. My lords, consider what your petitions are asking you to do. They do not only allege that a procedural step was skipped or that a specific right was violated, but all they tell you is that something wrong happened. Why? Because had something right happened, these are not impeachable grounds. Inviting you now to deep dive into the case and look at the granular and then ask whether Senate acted responsibly. We seek to persuade you that that is not a path that this court should take, because the Constitution forbids it, and because binding precedent by the Supreme Court and the Court of Appeal prohibit it. In the Philippines, the court offered a further caution for the court to bear in mind, that the court has to distinguish between two failures of judicial duty. The first is the failure to exercise supervisory jurisdiction where a genuine constitutional violation can be identified. That can be one area. However, the other one is the failure of restraint that results in courts purporting to review the merits of impeachment proceedings. So, my lords, you are between the devil and the sea. If there is a constitutional violation of the petitioner's rights, your scrutiny must be enhanced. But if you do not find any of that, then you must not take any other step, because that other step would be to review the merits of how Parliament got to where it did. The Philippine court was very emphatic that the political question doctrine cannot be used as a shield to avoid adjudicating genuine constitutional violations. Secondly, the court was equally clear that when asked to consider whether the offenses alleged to the complaint constituted valid impeachables, the court held without hesitation that, and I quote now, goes into the merits of the second impeachment complaint over which this court has no jurisdiction, and that it would require this court to make a determination of what constitutes an impeachable offense. This is a purely political question which the court has left for the sole discretion of the legislature. Now, my lords, it is our very humble submissions that if to the judgment of unelected judges. And I don't say, when I say unelected judges, my lord, it is not in any way to suggest that the judiciary has less legitimacy because it is not elected. No, 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 no. All arms have legitimacy. But in the political space, it is the elected representatives who should make political decisions because they are politically accountable. As I have suggested, they can be punished by the voters at the coming election. There is one point where it was very difficult for me to follow the argument, and I want to turn to this area now. And this is about plenary versus special committee argument. Again, it's an area where the law is settled. The law is settled by the text. Even before we got to the spirit of the text, we don't need to call the spirit of the text. My lords, we have dealt with this matter at great length from paragraph 43 to 75. No, sorry, the petitioner has dealt with it at great length from paragraph 53 to 75 of his submission, which must mean that in his opinion, this is a very, very important argument in his petition. He advances his case through three distinct lines of argument. One is a historical argument drawn from constitutional drafts, a grammatical argument based on the word "and" in Article 145.3, and what I shall call a distinction argument. Then the contention that plenary and special committee are so materially different in their procedural protection that only the latter meets the constitutional standards of fairness. With respect, all these three arguments hold no water whatsoever. Let's start with a plain reading of Article 1453. I read it as follows. Within 7 days after receiving notice of a resolution from the Speaker of the National Assembly, the Speaker of the Senate shall convene a meeting of the Senate to hear the charges against the President and mutatis mutandis, the Deputy President. And B, the Senate may appoint a special committee comprising 11 of its members to investigate the matter. Now let us see how this argument is then handled by my distinguished colleagues for the petitioner. They say that Article 145(3)(b) is discretionary. The Senate may appoint a committee. I have the floor. My lords, the constitutional text is unambiguous. It is unambiguous. It invites no further, it brooks no argument. How can may be shall? What would have been easier than the draftsman to say, the Senate by resolution shall appoint a special committee? It says may appoint a special committee. May appears precisely where the Constitution intends discretion. When the Constitution intends compulsion, it uses shall. Let us see what it does in Article 1453A. And it does the same in Article 1527A. This requires the National Assembly to appoint a select committee to investigate a motion against a cabinet secretary. The draftsman is aware that in these two articles, 1453 and in Article 157, he requires it as mandatory, and he says so. The two words appear in the same article, separated by a semicolon within the same clause. The drafters placed them there side by side. Their choice of may in sub-article B was not accidental. It is deliberate. It is visible. It is elementary. What do my distinguished learned friends ask you to do? They ask you, my lords, to read may to mean shall. That is not constitutional interpretation. They are not interpreting the Constitution. This is rewriting the Constitution. They're saying that the draftsman wasn't clever enough. He should have used shall. Well, the draftsman wrote what he was told that the drafters of our Constitution wanted. There's an irony in that the very people who invoke the Constitution as a protection of their rights abandon it when it doesn't say the things they wanted to say. Where the plain language of the Constitution of the law is clear, there is no reason for the court to be creative. It is quite obvious that the draftsman knew when to use may and knew when to use shall, and in this particular instance did not use shall. It is Parliament, and I will show that this court itself, the Supreme Court in Sonko, I will go back to to Sonko. The Supreme Court in Sonko says at paragraph 129, quote, "The charges can be heard in the Senate plenary or in a forum of a specific committee." Again, the argument that my learned colleagues make is been shut down by the binding precedent of the Supreme Court, that is Sonko. So you are being invited, my lords, to accept a reasoning that the Supreme Court has said is not available. Now, the historical argument is even more baffling. Petitioner, and I think this point was argued by my very distinguished young friend, Mr. Dudley. It traces the history of Article 145 from the Bomas draft, the Guy draft, the harmonized draft, the revised harmonized draft. And it's covered in paragraph 56 to 71 of his submission. He invites this court to read the deliberate change from shall to may as an accidental product of drafting compromise rather than a purposeful constitutional choice. With the greatest respect, that argument is inadmissible as a matter of interpretive principle, and it is self-defeating as a matter of substance. Why do I say that? Again, it is a matter where the courts have had great clarity. The Court of Appeal in Mongare versus the Attorney General and 3 others, 2014, Kenya Law Reports, a very strong court, a five-bench court of appeal of Justice Kiage, Justice Murgo, Justice Sichale, Justice Otieno Odek, and Justice Jamila Mohammed. Five-bench. They set out the conditions under which a court may properly resort to historical background and the preparatory text, as they call it in international law. The threshold condition is unambiguous. The text must itself be ambiguous, number one. The text must be ambiguous. It must be doubtful or obscure, or such as to lead to a contradictory or conflicting meaning when literally constructed. Now, it is our submission that where the text is clear, history has no role to play. The court said this further down in its judgment at paragraph 132. Unless there is ambiguity in the words and phrases used, the historical background and the preparatory text, I'm saying it in English, although it's written in French, to the Constitution shall have a very limited role to the interpretation of the Constitution. The use of historical text is actually not part of the English common law. It finds its way in mainstream law from the civil law into international law. But that's an aside. So, what do they finally say? And this is very important, my lords. We are seeking not what the drafters of the Constitution meant, but the true meaning of what they said. Even if there had been 100 conversations in the back room, what actually, finally, the draftsman was told to capture is what the court is interested in. We submit that the text of Article 145(3)(b) is not ambiguous. May does not mean shall. It has never meant shall. No party before this court has submitted that may, in any other context other than this, has ever been treated as being doubtful or obscure. If we were interpreting a contract or a will, or we were reading a mortgage document, nobody would have the courage to raise the argument that may means shall. It's only in this context of nebulous constitutional concepts that somebody has the courage to make that argument. On substance, this argument is equally unavailing. The Court of Appeal in Mongare cautioned that where a provision emerges from contested negotiations, its drafting history offers no stable interpretive guide. Competing narratives can be drawn from the same record, making it unsuitable as a determinative canon. The Mongare Court identified the inherent danger plainly. The historical background to constitution making is, quote, these are the court's words, is fraught with competing emotive, sectarian, religious, partisan, ethnic, economic, and political undertones, end of quote. So it is not useful to say at one point the drafters had shall. Then at one point they dropped it, they said may. So we ought to go back to what they dropped because it must be what they intended. That argument is not sound. Now, my lords, even if you were minded to look at the history, which we strongly discourage you from doing, and doubt that you will, because you yourself, on another occasion, have pronounced yourself in this same petition on that point that they repeat now. In Gachagua and 40 others for the Speaker of the National Assembly and 15 others, 2024, you, my lords, you declined the same argument that has now, is now being refreshed, it's been defrosted, and it's being served a second time. And you say, the petitioner cannot invoke that history to answer one question, whether the court sets aside to answer another. Consistency in interpretation, itself a dimension of the rule of law, requires the same approach here. The text governs. The text is clear. The inquiry ends. In fact, I like your language more. I like your language more than that of the Court of Appeal. It's very, very clear. You say the inquiry ends here. So why has this argument been rehashed before you? I have no idea. It had no merit then, it has no merit now. Now, then they make another equally baffling argument. They say, if you draw on the Supreme Court's advisory observation in Sonko, the committee route is desirable for future impeachments because plenary proceedings are inherently unfair because they create a more lynching environment in which senators are not individually engaged with the charges. I assume this new language, Supreme Court's advisory observations, is what in my day we used to call the court's obiter dicta. The court pronouncing itself on matters that it is not called upon to do in order to reach the ratio of the ratio descended die. I don't know whether maybe language has changed these days, but the substance remains. Even if the court said in the future, in its opinion, it desires, it thinks it would be better to go the committee route or not, that is obiter dicta. It is not part of the ratio descended die of the Sonko case and is of no value whatsoever. But even let us assume that we should give Supreme Court dicta some respect, some weight, because it's our apex court. Then we would still end up here. The Supreme Court doesn't say that not holding that plenary proceedings, not holding that proceeding is constitutionally unacceptable. The court doesn't say that. It doesn't arrive at that conclusion. The operative finding, the ratio descended die of the Sonko case is at paragraph 129. The charges can be heard in plenary which is exactly what happened in this petition before you. Due process concerns about the fairness of plenary proceedings are evidentiary questions that must be demonstrated in the specific circumstances of. Okay. I am corrected by my learned and distinguished friend, Dr. Muthomi Thionkolu, that the dicta I have referred to is actually from the High Court of Kenya, but it has equal force. I apologize for that. Now, my Lord, it's amazing in our profession how we come across matters that resemble each other almost on all fours, like the old judges used to say. This very point taken by my distinguished learned friends was taken up by an American judge called Nixon. Nixon had been found guilty of some impropriety. And proceedings were commenced, because he was a federal judge, to remove him from the federal bench. Now, because you are a federal judge, the removal must be done by Congress. Now, Nixon, having found himself before Congress, found that Congress went the committee route. In its wisdom, it set up a committee, and then the committee brought the report to the whole House. The full Senate then received short briefs, it had oral argument, and then voted 2/3 majority to convict. The petitioner argued that this procedure impeached Clause 1 of the US Constitution, which vests in the Senate the sole power to try all impeachments. Nixon was making the opposite argument from your petitioner. Your petitioner is saying, I want to go before the committee. Yeah? And Nixon is saying, I don't want to go before the committee, I want to go before the whole Congress. So how was this handled? The majority's holding in Nixon versus the United States, US 1993, the majority held on this plenary versus committee question that it rested on the text. The court observed at page 230 that the impeachment trial clause imposes precisely 3 specific procedural requirements. 1, the Senate shall be under oath. 2, a 2/3 vote is required to convict. And when the president is being tried, the Chief Justice preside. It held that the specificity of these 3 express requirements were determinative of the matter. The framers knew how to impose procedural constraints when they intended, and their choice not to impose any further constraints as the mode of hearing was deliberate. And this is how the court put it, and I quote, "The Constitution speaks in general terms, leaving Congress to deal with subsidiary matters of detail as the public interest and the changing conditions may require." The parallel to Article 1453 is direct. Just as Article 1 of the US Constitution imposes specific requirements, leaving the modalities to the Senate, Article 1453 of our Constitution imposes specific requirements. The Speaker shall convene within 7 days. The Senate may appoint a committee, while leaving it to the Senate to mandate how to determine the conduct of the trial. The framers of our Constitution, like their American counterparts, knew how to impose a mandatory requirement, and they would use shall. They did so in Article 1453A. They did not do so in Article 1453B. The lesson of Nixon is that courts should not read additional procedural constraints into impeachment provisions beyond those which the text itself stipulates. My lords, do you want me to continue?
Do you want to continue?
Yeah, I think if you give me another 15 minutes, I would wrap up 2 arguments. Then I would surrender the floor to my colleagues tomorrow morning.
All right.
I wish to make 2 other points. The constitutional architecture that the framers finally agreed on must be respected. And in my very humble submissions, what your petitioners are asking you to do is to recognize a judicial veto to impeachment. A judicial veto to impeachment. I think that that would be a massive judicial overreach that would destabilize the separation of powers in our own republic. I now come to one last point, and this point relates to the presidential prerogative to nominate the deputy president. I think, again, the language of 1491 is very, very self-evident. And it says this: within 14 days after a vacancy in the office of the deputy president, the president shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. That is what the Constitution requires. In fact, if by the 13th day the president hasn't acted, a public interest litigator like my friend Cheng Dudley can begin to prepare a petition to say the president is violating the Constitution because he should have appointed a deputy president. Now, even as we speak about public participation and all other things, we must remember this. The appointment of a new deputy president to replace an impeached one is not an election. It is the sole prerogative of the president that the Constitution has donated to him. The president nominates. There are only 2 functions here. The president nominates, says, my nominee is Mr. X, and then he takes it to Parliament, and Parliament can say no, or Parliament can say yes. Those are the only 2 actors. So when there is a collateral attack on my old client's IEBC, I do not understand how it is to be entertained. The Constitution does not make the president's exercise of his prerogative conditional upon his nominee being cleared by IEBC. He may do so out of an abundance of caution. He may ask, could you please tell me whether my nominee is a registered voter? He may ask the Bureau of Registration, can you please check for me whether this man is a Kenyan? He may ask the Department of Immigration, does he hold more than 1 nationality? That is due diligence. He's not getting clearance from them. So I do not understand the argument that attacks, although they are in the very, very, very able hands of my learned friends here, but we do not understand how that is. I therefore submit in conclusion that in the view of the Honorable the Attorney General, the Chief Legal Advisor of the Government of the Republic of Kenya, it has not been demonstrated in any of the petitions argued before you that there was a violation of the constitutional rights of your petitioner, and it has not been demonstrated that this court is vested with a jurisdiction to review anything else other than that. I respectfully submit, and I thank you for your time.
Thank you. Just for purposes of housekeeping, how many submissions will we be having tomorrow?
If I could respond from the convenience of this stage.
Yes.
Given your directions, I think we may need to have to confer as counsel appearing for the respondents, because there are those who will be speaking on behalf of the National Assembly and those who will be speaking on behalf of the Senate. Now, those two teams have an element in the submissions that is touching on the question of fair hearing. Fair hearing is what is tied to the affidavit in respect of which you gave directions that we need to put in our responses by next week. So what we may want to confer over is whether, and subject to your guidance again, my lords and my lady, whether it would be helpful to have that team that will not be touching anything on fair hearing proceed tomorrow, or whether it would actually make better sense to consolidate our submissions and appear before you on the day that you've assigned. When we had our own conversations, we thought that if you gave us a block of 5 to 6 hours, those who are left, we should be able to fit within.
I think, my lord, just on equality of arms alone, the petitioners took 12 hours. 12. Professor Githu seems to have taken 1 hour, or just about 2. So we have about 10 hours to go. But, my lord, within that frame, the team from Senate that I lead is confronted with a very heavy argument on fair trial and all those questions that are in the affidavit filed by the affidavit of the 28th of April. And my lord, we would want to have, we will probably be filing responses by Monday, as you've stated. We'll probably have Dr. Gikonyo for lunch on that day, so that we then can just deal with him squarely on when RG, which would mean Robin Gitau or any other person, was admitted, all those issues. And my lord, it may therefore be premature for us to proceed on our part as Senate, because the matters in question touch on the live proceedings in Senate, and that means we have to have our response so that we deal with the substance that Dr. Mudomi tried dealing with when he was responding, so that the court can then make a comprehensive, a composite decision on whether or not there was an illness and whether or not Senate had an opportunity to deal with the issues that Paul Mwita, Senior Counsel, my pupil master, was not able to appraise us of on the afternoon of the 17th, when suddenly his client was in. Your client was here in the morning, he disappeared. He disappeared. He was not there in the afternoon.
An objection. This is the second time Professor Otienda is false, saying I did not inform the Senate. Your Lordships, Your Ladyship, you have the answer of the Senate on the 17th of October. If you go through that answer, and I'm sure you will find that at 2:30 p.m. on the 17th of October, when the hearing resumed, I informed the Senate that I have been unable to contact my client, the petitioner. And I was given a bit of time to try and contact the petitioner, His Excellency regarding Gachagua. The answer your father showed that I then informed the Senate that regarding Gachagua had been admitted into current hospital. And that is when I asked for an adjournment until Thursday. And the Speaker then puts the matter to the vote as to whether they could adjourn until the following day, Saturday. The Hansard will also disclose that I pointed out that under Article 145, 15 days related to the committee, not to the Senate when it was hearing the matter in the plenary. And that therefore, the Senate was wrong in saying they had to finish that matter the following day by Tuesday. All that is on the record. And finally, this is not what I taught my pupil, Professor. I taught him to always tell the truth.
My Lord, I was interrupted. I was unfairly interrupted by my pupil master. But my Lord, the point was that there was time given between 3 to 5 p.m. And none of the affidavits or what is displayed in the affidavits was presented to Senate. So I'm just stating, my Lord, that we would then need to respond. And that is why perhaps tomorrow, on our part, we may not be able to proceed. We may ask the court for a date after the responses. Then we'll make a decision on whether or not we'll want Gikonyo in court or whether we just want to respond, because the Senate as an independent arm or organ did its trial properly within the law as clearly submitted. And we should deal with all those issues, my Lord, as set out in the affidavit of Nyegenye, the clerk to the Senate. So I think I'm sure we'll all agree that we file first, then we then submit after that for Senate.
Yeah, my Lord, just before you give your directions, I've also had opportunity to confer with my colleagues with whom we are representing the National Assembly, together with counsel appearing for Mr. Mutuse. And it would appear, from what you can see playing out, that the question of fair hearing cuts across each of the respondents. And so the proposal would be that we then all come on that 13th. You give us a block date on which we will then deal with all our responses, particularly because Professor Gidhu has finished, and I think we can't go beyond a day. In any case, we'll still need to take instructions and confer as between ourselves as to whether it might even be necessary to subject the Honorable Rigathi Gachagua to a second medical opinion. So these are things that would have a bearing onto what we'll be responding to, and it may be important for us to get time before we come before you. Our plea, therefore, is that you allow us to to come up on the 13th, take the date for our responses. Most obliged.
My Lord, on behalf of the second interested party, we will need, when we get there, at least 2 hours to highlight our submissions. The reason is that many allegations are made against our client, His Excellency Professor Kithure Kindiki, and he is the person who perhaps stands to lose most should these petitions succeed. If the relief sought against his nomination and approval by the National Assembly. And lastly, I can confirm we have instructions to cross-examine Dr. Gikonyo. So as you give your directions, maybe you may want to weigh that also.
So nobody's ready to proceed tomorrow?
My Lord, from the petitioner's side, we've conferred, and our suggestion is that There are other respondents the court can hear tomorrow. We are ready to come before the court for this hearing. And the court had already given, the court, my lord, had already given directions when it ruled on the matter of the affidavit, and I won't be long, my lord. On the question of a second medical examination, my lord, with respect to my learned friend and very good friend, Mr. Gumbo, this is not a running down claim. It's only the Insurance Act that mandatorily requires a second medical examination. I am on my feet, my lord, if I conclude. So that issue is a non-issue in the proceedings before you. In any case, it is res judicata. You've already ruled on the manner that the affidavit and cross-examination of Dr. Gikonyo will be conducted on the adjourned date. You also gave a date. And you then ruled that tomorrow we proceed with highlighting of submissions and reserve the adjourned date for further proceedings then. Thank you, my lord.
My lord, if I may just put a few things on record on behalf of the respondent. My lord, the petitioners have introduced in a most unprocedural manner, but the court has regularized that, an affidavit that contains a medical report. Now, it is evidence 101 that there is no amount of cross-examination that you can subject a professional who has proffered a professional opinion. If that medical report is on record, the only way we can counter that medical report, my lord, is by another medical report. And to produce a medical report, the subject of that medical report must be examined by another doctor. It is our right to determine how we respond. Once they have introduced it, it is not for them to determine how we respond to it. That is how we have chosen to respond to it, not them, nor the court can dictate how we respond. So that is the manner in which we want to proceed, unless, of course, they want to withdraw that medical report so that we can proceed even tonight. I'm most obliged.
What we want to know...
I can also confirm if they are willing to withdraw it, we can also proceed even tonight.
We have not asked for any assistance by seeing our client, the petitioner, or making decisions. If we ever came to that, we would definitely do so directly to you without embarrassing the court by making the requests through the court. But my lords, your ladyship, we want this matter to proceed along the lines that the court had already outlined in the directions, which we are clear that our opponents here proceed with highlighting their submissions, leaving out only the issue of the report by Dr. Gikonyo. And without any hesitation, we agreed to avail Dr. Gikonyo as a witness here. I would plead that the court sticks to those directions so that we utilize tomorrow, then we come back and Dr. Gikonyo will be here for cross-examination.
I think we have given directions on how we want to proceed. And it's also important that Council also consider that you are not the only parties in this place. Judiciary, us also, we must consider us. This is a three-judge bench. We have tried to manage to manage our program. We also have a program. And this is not the only work that we are doing. We are in several benches and our usual course list. Any delay of 1 day can take this matter to July. Any delay of 1 day can take this matter to July or September. So you must also decide how you want to proceed. Because, again, Even this hall, we procure it at a serious cost. If we adjourn today, we will not be able to provide you with this hall because this hall, we paid for it, we procured it, and we paid a lot of money for it. So if we lose tomorrow, we'll go back to our small court. And several other things. I would want to urge this, that repetition is not bad. Let us proceed the way you had planned. You can still repeat yourself on Wednesday, if need be. Because we said the issues concerning the affidavit can be adjudicated separately. But if you feel that you want to repeat yourself on those issues, there's no problem. But we must proceed tomorrow. There are other people, other parties here, IEBC and several other people. Dr. Kenkulu, you have no problem proceeding tomorrow?
I have no problem, my lord.
Yes. We will proceed tomorrow as from We will proceed tomorrow as from 10.
Just before you rise, in a quick consultation, we stand guided by your directions, just the slight variation being that the council appearing for the National Assembly and the Senate would then be yielding ground so that any other respondent who is ready to proceed tomorrow can proceed, but you then reserve time for us on Wednesday after we'll have put our records in place.
That is okay.
Most of that.
Yeah, so the rest of the respondents, we can hear you tomorrow.
Well, that it would appear that there could just be one or two respondents at most for tomorrow, just so that we project on how we'll use the day tomorrow.
Who are they? Who are they for tomorrow?
Kamodo, for the 10th respondent,
Yes.
on our part, we would rather proceed on Wednesday. So may it go on record that tomorrow we may not be in a position to participate, given that we will need to consult on that critical issue about the affidavit, which in a heavy way touches on critical clients who are part of our party, the party leader and the deputy party leader, who have been put at an adverse position in that affidavit.
Just sit down. Just sit down. I think we will not be in a position to compel you to proceed tomorrow. We'll proceed on Wednesday in Court 118. We proceed on Wednesday in Court 118. We are not prepared to procure this place again.
We are most obliged.
At what time? At 9. So we adjourn the matter to 13th of May, that is next Wednesday, at 9 a.m., courtroom 418, 418, our usual court. Thank you very much.
The KPC Lucas Scholarship Program is a program that began 9 years ago, and it targets specifically students living with disability whom we are able to recruit, take throughout the 4 years of their high school education, and then we're able to transition them into university for those who meet the required grades.
I've got to benefit through the lessons they've taught me about leadership, confidence, how to coordinate myself, how I can prevent the stigma, and how I can just carry myself.
Subscription for non-stop entertainment, drama, sports, movies, kids, reality, and news. Download the StarTimes On app to enjoy all your favorite shows and stream live channels on the move. StarTimes, enjoy digital life.
Raise your arms with confidence with Nivea Derma Control. Life doesn't slow down, and your protection shouldn't either. From long days to busy schedules to moments that matter, you need something that keeps up. Nivea Derma Control.
Imagine a delicate scent, so quiet yet so comforting. A mild fragrance that gently drifts you into pure serenity. That's Downy Pure Bliss, crafted and infused with natural essential oils. It keeps my clothes fresh all day and into the night.
You smell like pure bliss.
New Downy Pure Bliss. Try it for only 20 shillings. Imagine a delicate scent, so quiet yet so comforting. A mild fragrance that gently drifts you into pure serenity. That's Downy Pure Bliss, crafted and infused with natural essential oils. It keeps my clothes fresh all day and into the night.
You smell like pure bliss.
New Downy Pure Bliss. Try it for only 20 shillings.
subscription for non-stop entertainment, drama, sports, movies, kids, reality, and news. Download the Star Times On app to enjoy all your favorite shows and stream live channels on the move. Star Times. Enjoy digital life.